Now I am going to dictate a legal passage based on latest Supreme Court judgment at the rate of 120 words per minute. Let's start. These foundational facts typically involve or correspond to proving those facts or elements that cogently establish the actor's reuse required for the offense alleged by the prosecution. Stop. It is only after such foundational facts have been proved beyond a reasonable doubt that the prosecution may take recourse of the statutory presumption provided by the legislature. Stop. The rationale behind the same is twofold. Stop. First, in the absence of any actor's reuse, there is no possible way to ascertain the corresponding means that is required to be established. Stop. This is because it is the actor's reuse which demarcates or delineates the means which is to be looked for and established. Stop. Without an actor's reuse of any form, there arises no question of establishing and consequently the means in view of the foundational principle of criminal jurisprudence, that no one should be punished for their thoughts or intention alone unless accompanied by some form of fact. Stop. Secondly, and more importantly, it ensures that the statutory presumption does not overreach to or take the place of proof of guilt under the guise of presumption of culpable mental state. Change. It would be too much to shift the entire onus onto the accused and to ask him to prove a negative fact. Stop. Thus, any statutory presumption would operate only after the prosecution first lays the foundational facts necessary for the offences that have been alleged beyond a reasonable doubt. Stop. This is because a negative cannot be proved in the initial threshold, in order to prove a contrary fact, the fact whose opposite is sought to be established must be proposed first. Stop. Thus, in law, it is tried that the initial burden always lies on the prosecution. Stop. This way, the establishment of foundational facts by the prosecution is a prerequisite for triggering the statutory presumption for shifting the onus on the accused to prove the contrary. Stop. It is a delicate balance struck between the practical need for such presumption in law and the cardinal principles of criminal jurisprudence to ensure that the presumption does not cross or transgress the fine line that demarcates presumption of culpable mental state from the presumption of guilt itself. Since a negative cannot be proved, an accused cannot be asked to disprove his guilt even before the fundamental allegations with supporting material thereof are placed and duly established by the prosecution before the court. Unless the prosecution is able to prove fundamental facts in the context of the allegations made against the accused under any specific provision of the POCSO, as the case may be, the statutory presumption of culpable mental state under section 30 of the POCSO will not come into the picture. Even if the prosecution establishes such foundational facts and the presumption is raised against the accused, he can rebut the same either by discrediting prosecution's case as improbable or absurd, or the accused could lead evidence to prove his defense in order to rebut the presumption. However, the said presumption under section 30 of the POCSO will be said to have been rebutted only where the accused by way of his defense establishes a fact contrary to the presumption and proves the same beyond a reasonable doubt. Foundational facts required under section 15 of the POCSO. Stop. Now coming to section 15 of the POCSO, as discussed earlier, Foundational facts ordinarily pertain to the actor's reuse required under particular offense stop. However, given the fact the section 15 penalizes three distinct and varying degrees of intention and having regard to the mutually exclusive nature of each of the three offenses provided there under the mere storage stop. Thank you.